Oh, the standards for admissibility at these hearings. Michigan Rule of Evidence 104. All right, back to the basics. What's the standard here? It's preponderance of evidence. And there's a lot of case law out there. All you got to do is just look for it. It's rudimentary, okay, but it's out there. Preponderance of evidence. So the prosecution, when you allege that the data master test was done wrong, the prosecutor must come back and prove by preponderance of evidence that the test was done correctly. I hear this one all the time. Actually, I don't know if any of you know Charlie Cooper. He's the prosecutor up in Novi and maybe a couple of other jurisdictions. But this fellow right here, he just reminds me of Charlie Cooper because Charlie's got this way of talking to the judge. He says, but judge, he hasn't proven that the test was done wrong. And that's how Charlie wins these arguments. With a smile and this, he didn't prove that the test was done wrong. Gilbert versus Daimler Chrysler, it's well established that the proponent of evidence bears the burden of establishing relevance and admissibility, citing People versus Crawford and describing that rule as basic Hornbook law. The prosecutor bears the responsibility of establishing both relevance and reliability, whether or not it's a breath test, a blood test, the eye test, or anything else. Field sobriety tests. One of my points that I want to get across to you today is to be creative when you're thinking about these cases. So we've all heard that a person's inability to walk heel to toe shows that they're intoxicated. Rethink that. Is it actually true? And where did we ever come up with that assumption that it was true, except that we had police officers tell us that? An important note regarding the Federal Rule of Evidence 104, this is a case, now I don't know how well established Michigan law is in this regard, but the federal notes indicate that when a preliminary and ultimate where there are preliminary and ultimate determinations involve the same questions, the trial judge who admits the evidence should not inform the jury that she has found in favor of admissibility requirement in the proponent's favor. To do so would improperly influence the jury's decision on the ultimate determination. This would be especially problematic in criminal cases where evidence is offered against the defendant. In that situation, the jury decides the ultimate question by a beyond a reasonable doubt standard of proof, whereas the trial judge decides preliminary questions by preponderance of evidence, citing United States versus Tracy, a 93 federal case. And in that case, it held that it was an error for the judge to rule or to say to the jury that she had found that the evidence was admissible. I ran across this exact situation just yesterday. I had an issue regarding the data master at a jury trial. The judge had previously ruled that the data master was going to come in, and during the course of the jury trial, the prosecutor jumped up and said, "Objection, Your Honor, you've already ruled that that evidence is admissible. And I am asking you to instruct the jury that you found that it was admissible." Wrong. Absolutely wrong. The judge decided that by preponderance of evidence. And here the jury had to decide it beyond reasonable doubt.